This is the moment a serial domestic abuser's luck runs out. We're about to see Joseph Chasen, a man who pleaded guilty to attacking his wife with shards of glass, stand before a judge and ask for mercy. His lawyer will paint a picture of a man who is a low risk, a loving son, and just a victim of a toxic relationship. He'll argue for probation, but the judge has read the file. He's seen the two-page criminal history filled with violence, intoxication, and protective order violations. And most importantly, he's seen the defendant's own words, a jaw-dropping statement to his probation officer that completely contradicts his sworn guilty plea. What follows is not just a sentencing, it's a systematic dismantling of a liar. The defendant will try to blame his victim, but the judge is waiting with the facts, and he is about to unleash a verbal storm that will shake the courtroom.
Are there any corrections or changes to it?
Defense has and no correction.
We have, and there are no objections or changes.
It's made a part of the record for all purposes. The defendant just pleaded to paragraph 1, I believe.
That's correct, Judge.
So the agreement here is whatever sentence shall not exceed a cap of 7 years. So no less than 2 nor more than 7 years. The defendant can also be placed on deferred or unadjudicated probation for up to 10 years. And regular probation, I believe, is not an option under this
That's correct.
circumstance under the allegations. We're going to start with Mr. Lane. You may go forward, sir.
Your Honor, we're asking the court to defer all proceedings and place Mr. Chasen on probation for a term of years, and that he be required to fulfill the conditions of the plan set out in the probation report. It does note that he is a low risk of reoffending. Your Honor, Mr. Chasen has been married for 16 years to the victim in this case. They have had altercations in the past. They've led to police being called, charges being dropped on both sides. And it just has turned out to be a toxic relationship. Mr. Chasen has, he was actually bonded out by the victim in this case. She was the first one to notify the bail bondsman to try to get him out. He does, with the 2 children, he has to pay child support. He just got a new job as a carpenter, doing some roofing and remodeling. He cash apps child support payments as best he can through his sister, who's very helpful. He does have a relationship with his 2 children. They are legally divorced over in Louisiana. That visitation at this time is supervised. And of course, the court knows if he does violate a condition of probation, if it doesn't go to anger management, he could get 180 days as a condition of probation. He could be sentenced to 20 years of prison. I've submitted to the court 17 support letters from his family, his siblings. All of them had stated that he is charitable, that he is a family man, that he is helpful, most importantly to his mother, whose ailments require daily help from Mr. Chasen. He is there. He remodeled their house along with another sibling. The letters also indicate that he's very encouraging to his siblings to stay in school, to stay at their job, fight the good fight, and that he had done what he could to give to his siblings what he had. He obviously needs to be away from his children's mother. They, as you've seen in the court's experience, they fight and get back together and fight and get back.
The defense has laid out its strategy, paint this as a two-sided toxic relationship that has now ended in divorce, making the defendant safe to release on probation. Mr. Lane emphasizes family support letters and the defendant's new job, framing this horrific act of violence as a simple fight that got out of hand. The argument is that since the defendant is only aggressive with his spouse and they are now separated, the community is safe. It's a classic defense tactic: minimize the crime and humanize the defendant. But watch the judge's reaction. He immediately latches on to the most glaring flaw in this logic. He's about to ask a question so sharp and so simple it cuts right through the defense's entire narrative and puts the defendant directly in the hot seat. The temperature in the room is about to skyrocket.
Back together. I submit to you that's what happened here. But other than that, there hasn't been aggression with anybody other than his spouse, is my understanding.
Of all people on the planet, to make the exception to that rule, your spouse?
This is a fatal mistake. Cornered by the judge's sharp questioning about his vows, the defendant, Joseph Chasen, does the one thing you should never do: he blames the victim. He retorts, "Whenever we got married, she wasn't on drugs." He tries to shift the entire focus onto her, painting himself as the one who was wronged, but the judge is more than prepared for this. He immediately pulls out the police report from the night of the assault, and the details are damning. The defendant wasn't just drinking, he was so considerably intoxicated that when the police found him, he was completely unresponsive. The judge calls him catatonic. In one swift move, the judge has not only destroyed the defendant's attempt to smear his victim, but has also completely obliterated his credibility. He just proved the defendant was in no state to even know what was happening, let alone offer a reliable account.
So everyone else on the planet, you're going to treat well, but it's your spouse that you feel like needs the living hell of a life? I mean, didn't you pay attention to your vows when you were married? Didn't you? Or were you intoxicated during that time like you were at this event?
Whenever we got married, she wasn't on drugs.
Sir, you were intoxicated. Here's what police woke you up and asked what happened. You were considerably intoxicated and you couldn't even respond. How would you even know what was happening? You're catatonic. Weren't you? You weren't drinking that night? You weren't intoxicated that night? You didn't even wake. Okay. Officers woke you up. What happened? They asked. You appeared to be considerably intoxicated and would not respond. These are police officers who deal with these situations every day. You don't think they can tell somebody's intoxicated or not? Okay, hold on. Let's see. You were on, let's see, probation, violating a protective order in 22. I guess this was involving the same lady. In 04, underage driving under the influence. We started out early, wasn't even an adult, and you were driving intoxicated. Let's see. Aggravated flight from an officer. 1 year hard labor for that in 05. Disturbing the peace by appearing in an intoxicated condition in 16. Pleaded guilty to that. Driving while intoxicated, second. That's a disposition unknown. Disturbing the peace by loud and profane language. That was.
Let's just take a breath and process what the judge just read. This isn't just a man who made one mistake. This is a rap sheet that tells a story spanning nearly 2 decades. It starts with underage DUIs, escalates to fleeing from police, and then settles into a horrifying, consistent pattern of domestic abuse. We've heard about domestic violence with a dangerous weapon, public intimidation, and domestic abuse with a child present. The judge's comment, "There's so much smoke here, it's got to be fire," is the understatement of the year. This isn't smoke, it's a raging inferno of criminal behavior. Every time the defense attorney tries to portray this incident as an isolated event, the judge pulls out another charge from the past, proving this is exactly who this man is. The defendant's claim of innocence is now utterly laughable.
Dismissed. Simple assault, dismissed. Disturbing the peace of my time. You keep getting arrested for stuff. And really, convictions are what's important, but there's so much smoke here, it's got to be fire. You're the one with this record. How many times have you been arrested? Can you even guess? Let's see. And the aggravated battery here in 17, domestic violence. Who was the victim in that case? Your wife? Yeah. Yeah. The lady who's so evil.
Just when you think the defense is out of arguments, they double down, insisting the defendant has a very strong family and won't reoffend. It's a plea based on hope and promises, but the judge is holding a document that incinerates that hope, the pre-sentence report, and this is where the case truly implodes for the defendant. First, he admitted to the probation officer that he drinks daily, but claims he does not have a problem, a classic red flag for any judge. But the real bombshell is his statement about the crime itself. He completely denied assaulting the victim and claimed he would have gone to trial if it wasn't for my record. He is simultaneously pleading for leniency for a crime while telling the court's own probation officer that he never even committed it. This is a level of hypocrisy that judges absolutely despise.
That you're saying is so evil, where you're completely innocent. So you pick up 1 year home incarceration, but that was revoked the following year. Let's see, domestic violence with a dangerous weapon, public intimidation. Wow. What a charge there, huh? In 2019, domestic abuse, battery with child present. In 21, the judge issued an order prohibiting you from possessing or purchasing a firearm. Well, we can read between the lines what that was all about. So you're the innocent one. What else?
Your Honor, he's not an evil or mean person that I see. I mean, we've seen him when they just like to beat on whoever they can, and the weakest ones is correct. He doesn't seem that way to me.
I'd say he has a consistent pattern. You want to, you don't need, you can label that evil or not, but there is no crime for being evil. I wish people weren't, but there are crimes for not following the rules of law, which he has been consistent in doing.
They have taken the steps. They have officially divorced. There is a visitation order in effect in Louisiana, which provides for protection of the victim in this case, and even children, if so. And I believe
This is the moment of truth, the legal checkmate. The judge has laid the trap perfectly. On one hand, he has a sworn document where the defendant, Joseph Chasen, admits under oath to God that he intentionally and knowingly cut his wife with glass. On the other hand, he has the defendant's statement to the probation officer claiming he did not touch her. The defendant cannot have it both ways. He is either lying to the court now or he committed perjury when he signed that plea deal. The judge's question is brutal in its simplicity. Are you lying today, or are you lying when you looked at me in the eye under oath and committed perjury then? The defendant is speechless. He's been caught in an undeniable lie, and in doing so has proven to the judge that he has no remorse, no respect for the law, and cannot be trusted. Probation is officially off the table.
the restrictions in probation here can also provide her the safety and the community. And I don't believe he'll reoffend, Your Honor. He has a very strong family. They've been in constant contact with me, as has he. He's back to work. I think he could do it.
Told the probation office that he drinks daily, but does not have a problem. During the pre-sentence interview, the defendant did not accept responsibility and denied assaulting the victim. I'm going to remind you here, like all cases that we go over we've done this thousands of times. And you signed a document under oath that states, in light of your statement here, that you're not taking responsibility. And here's my favorite one. If it wasn't for my record, I would have gone to trial. That's just pathetic.
The prosecutor steps up and hammers the final nails into the coffin of the defense's argument. He masterfully refocuses the court on the true victims. He reminds everyone that this wasn't just an assault on a spouse, but that the defendant's own 7-year-old child was present to witness it. This is a critical point that amplifies the severity of the crime. He then validates the judge's assessment, stating Chasen's conduct is consistent and that he refuses to accept responsibility. The prosecutor even gives a peek behind the curtain, revealing that the state initially wanted 10 years and only offered this 7-year cap because of good lawyering by the defense. This masterfully frames the state as already being lenient and suggests that any further reduction would be an injustice. He's effectively told the judge, "We already gave him a deal, don't give him another one."
I did not touch her, but yet under oath, you signed a.
With every argument for probation systematically dismantled, the defense is now in pure damage control mode. The plea has shifted from "he deserves probation" to "if you have to send him to prison, please don't send him for too long." Asking for a sentence closer to the minimum is a sign of desperation. They know they've lost. The judge's follow-up questions are dripping with sarcasm and disbelief. When the defense argues prison time will be a deterrent, the judge shoots back. How about protection in the community? He's making it crystal clear that his primary concern isn't rehabilitating this man, who has proven he doesn't want it, but protecting society and especially his family from him. The defendant is about to be given one last chance to speak. Will he finally show a shred of genuine remorse, or will he dig his hole even deeper?
Sworn document that I am mentally competent to enter my plea, which is freely and voluntarily made. I've read the indictment. The attorney has explained it to me. I have committed each and every allegation charged. I am guilty of the offense and any lesser included offenses alleged against me. I swear all of this is true. So help me God. What you pleaded guilty to that we went over was that you intentionally and knowingly and recklessly caused bodily injury to Maggie Chasen by the use of a deadly weapon, namely glass, by cutting her. And in the manner of its use and intended use, glass shards.
This is more than a sentencing, it's a condemnation. The judge's voice is filled with a raw, controlled fury as he delivers a speech that goes far beyond legal jargon. Calling the defendant's life a twilight zone perfectly captures the twisted reality of someone who claims to love their family while terrorizing them. He's not just sentencing a crime, he's passing judgment on a man's character. When he says, "You betrayed those vows, you betrayed the laws," he's holding the defendant accountable on both a moral and a legal level. The judge's final question is a chilling one. If you would do this to someone you claim to love, what horrors would you be capable of inflicting on a stranger? He is painting a picture of a man who is a danger not just to his family but to everyone. The sentence is coming, and it's going to be delivered with the full weight of this righteous anger.
Are capable of causing serious bodily injury. And that you cut her, a member of your family, with the glass. Signed, your name, I swear to God, all that's true. So, are you lying today, or are you lying when you looked at me in the eye under oath and committed perjury then?
No, sir.
No, sir, what?
No,
Well, but you admitted you did
Yes,
it
I
all
did.
under oath.
yes, sir.
Is that what you're standing by,
Sir.
sir?
Yes, sir.
Sounded differently a few minutes ago. You weren't guilty of it. Let's stay absent.
Judge, I don't feel that probation is warranted, number one.
6 years in prison. And the judge made sure to add an affirmative finding that a deadly weapon, the glass shards, was used. This deadly weapon finding is critical because it significantly limits the defendant's eligibility for parole. The judge's decision was absolute. Joseph Chasen didn't just get sentenced for his crime. He was sentenced for his arrogance, his lies, and his complete lack of remorse. He walked into court asking for probation and walked out in cuffs because he fundamentally misunderstood the person he was facing. He thought he could manipulate the system, blame his victim, and lie under oath without consequence. He was wrong. The judge saw through every deception and delivered a sentence that prioritized the safety of the community over the hollow promises of a proven abuser. What do you think of the sentence? Was 6 years enough? Let us know your thoughts in the comments and subscribe for more courtroom breakdowns.
One, because he doesn't truly accept responsibility for his actions. Number two, we've basically been trying to make the complainant out to be the bad person. And the court is focused a lot on that, and I appreciate that. I want to highlight the fact that his child was present at this occasion as well. 7 years old. She was listed as one of the witnesses as well. And apparently, when looking through his history of the 6 different domestic matters that he was arrested on, apparently a child was present at one in 2019. So I disagree with his lawyer. I feel that his conduct is consistent. He chooses to drink on a daily basis. He makes bad choices. Obviously, when he's drunk, that's apparent from the 2 pages worth of criminal history that we have here. He's not eligible for probation from a jury. That's why Mr. Lane convinced my trial partner to allow him to cap this agreement to make the pitch that he did today. If he, however, had maybe had some different statements to your probation officer, he might have gone off on a stronger foot. But the reality is he doesn't accept responsibility. His kids have already seen too much of this. His wife at that time is nothing more than the victim, and certainly not the scapegoat in this matter. The state was at a point when this case was on the trial docket, suggesting 10 years. It was only through good lawyering by Mr. Lane that we conceded and did this cap agreement here. I agree with Mr. Laird, and what's appropriate here is 7 years.
All right. Rebuttal, anything else?
Well, Your Honor, we disagree with that. We think that the conditions of probation will provide the protection for.
But he's failed in probation before.
Your Honor, if the court is inclined to place him in prison, he did 1 year, actually 10.5 months on this previous deal. We would ask the court to go closer to the minimum condition. He doesn't care. That is going to provide, well, the deterrence that the system requires. And
How about protection in the community and in the home from this man's repeated disturbing behavior of violence and in constant intoxication?
I understand. And Mr. Chason would like to address the court.
Yeah. What else would you like to say?
I mean, probation, I mess up and also always manage.
You made a promise when you were placed on probation the last time that you made a promise to the court and you failed that, right? All courts make have the same set of documents essentially, and you make a promise. I swear I will follow all the terms, and I know I can be revoked, and that's what happened.
Do anything I have to do.
You know what you need to do is live in peace with the people you quote that you state and purport to say that you love and care for. I can't imagine anyone, much less someone I care for and profess love as a spouse like mine or yours, that you would quite naturally be in a constant state of intoxication as a role model, which is poor. But number next, you threaten to cut somebody with shards of glass. I mean, that's just. That's a twilight zone of a life. That doesn't have anything close to love and honor and commitment and loyalty. You betrayed those vows. You betrayed the laws. You defied the laws, and you committed a crime. And it's a violent crime. And it begs the question: if you would do this for someone you love, you say you love, if you do this to them, what would you do for somebody who you decided you needed to harm, who you had no association with? It's a frightening thought. You have pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There's sufficient evidence supporting a guilty plea. State's Exhibit 1 admitted here in the plea hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. There will be an affirmative finding on the judgment rendered that a deadly weapon, namely glass, was used in the commission of this offense, and that will be rendered on the judgment. Anything else?